All right. Mr. Effiong, as we wind down now, the President's Senior Special Assistant on Media, Mr. Bayo Onanuga, has been speaking on the participation of Mr. Aloy Ejimakor in the protests. I'm quoting from his verified Twitter handle now, X handle. He said, as a lawyer, you should be aware of the principle of sub judice, particularly in relation to the ongoing treason case before the court. The prosecution has concluded its case, and it's now incumbent on Mr. Ejimakor and the other lawyers to mount a strong defense for Kanu. He said rather than focus on preparing a strong case, Mr. Ejimakor has resorted to extra-legal tactics, joining a career anarchist to influence the process. Was it wrong for Mr. Ejimakor to participate in the protest?
What was he protesting? That is the first question. You know, in this country, we sometimes listen to some of these public officers and we cannot but be amused. When Mr. Onanuga made that comment, did he tell you what Mr. Ejimakor was protesting against? Was he protesting against the judge? The answer is no. Was he protesting against the witnesses listed that testified against Kanu? The answer is no. Was he even protesting, right, against the trial of Kanu? Can you show me one video where Mr. Ejimakor made a comment prejudicial to the trial? There is no provision. And I want a lawyer in Nigeria to come and contradict me. Because I listen to some of my colleagues, including some senior advocates of Nigeria, quite sadly, come on television to mislead Nigerians. I am putting it on record this morning that there is no law, there is no provision of the rules of professional conduct for legal practitioners 2025 that prohibits a lawyer that is involved in litigation from commenting on that litigation, from commenting on that suit. What our rules of conduct, rules of ethics, prevents is making comments prejudicial to the case. That is comment that tends to preempt the outcome or that tends to basically take over the conduct of the case. So assuming that Mr. Aloy Ejimakor had, during the protest, granted an interview and said, for example, oh, this judge that is trying Nnamdi Kanu, I can put it to you, is biased. This judge has been compromised. The witnesses, we are going to deal with them. The witnesses are not credible. The exhibit that was tendered was fabricated. If he had made those comments along those lines, one can maybe suggest that he had made comments prejudicial to the trial. That is why when you see public, serious cases take place, right, cases of public interest after the hearing, you will see the media. You have judicial correspondence. Go to the Federal High Court this morning after you are done interviewing me. Go and you see lawyers that have concluded cases of public interest. They address the media. It is not strange. It is not a violation of the law. It is what you say that matters. But let us even take the conversation further. Are you saying that because he's a legal practitioner, his right to freedom of expression under Section 39 is extinguished? Are you saying that he has no right to express himself, to articulate his position as a Nigerian because he's a counsel on record to Nnamdi Kanu? I think what we are seeing is a further shrinking of the civic space. Let me I don't know how much time I have, but let me, in rounding up,